Welcome back to another episode of Estate Planning Nightmares and How to Avoid Them. I'm John Braddock, the author of Click Here When I Die, the founder of My Life and Wishes, the Legacy Vault, which is an online planning and document storage solution created to make things easier for those you love. Today, I'm excited. I have a very special guest with me who is dedicated to helping families and business owners take control of their legacy. Joining me is Attorney Peter Osman. Peter is a highly respected estate, business planning, and elder law attorney based in Wisconsin. He's a graduate of the University of Wisconsin Law School and has built a career around guiding individuals, families, and businesses through the complexities of estate planning, trust creation, and Medicaid asset protection. As a founding member of Borakove Osman LLC, he and his firm believe that every client has two legacies: one to build today, and the other to leave for the future. Their approach is hands-on, ensuring that estate and business succession plans are not just attorney reviewed, but attorney prepared, providing real value and peace of mind to those they work with. Beyond his legal experience, Peter is also a passionate educator, regularly hosting workshops on topics like special needs planning, Medicaid qualification, and planning for taxable estates. When he's not helping clients secure their future, you might find him out on the golf course or boating and giving back to his community as a youth sports coach and president of the St. Stephen's Foundation, which supports St. Stephen's Lutheran Church. Today, we will be diving into some critical estate planning topics with Peter, so buckle up. It's sure to be a good ride. Peter, welcome, my friend.
Thanks, John. Appreciate the intro.
Oh, you're very welcome. Did I leave anything out?
No, I think you got it all. That's perfect. Appreciate it. How
Uh,
are you doing?
Doing well, thank you.
Good.
Um, so hey, let's jump right in. Yeah, as my audience knows, I like to talk about passion, right? What gets us up in the morning and has us do what we do. And as an estate planning attorney, I always like to ask, why estate planning when there's so many other practice areas in the legal field?
Yeah, no, it's a great question, and I think in some ways I'm a bit of an outlier in that I knew I wanted to do estate planning before going to law school. A lot of folks pick their practice areas during law school. I had the opportunity through some family friends to sort of not necessarily job shadow, but pick the brains of some estate planning attorneys in the Madison area before deciding to go to law school. And the motivation for me was always just wanting to help families. For me, the motivation to go to law school wasn't necessarily just the law in general, but finding a way that I could use the law to help others. And so, estate planning, as compared to a lot of practice areas, is not adversarial in most cases. Rarely are we. In fact, we're trying to prevent adversarial situations in the future through by planning in advance. So, for me, the motivation was always being able to help families stay together, families plan for the future, and really avoid those, as you would put it, estate planning nightmares, right?
Absolutely, absolutely. And what I really love about the state planning attorneys is it's so proactive,
Yeah.
versus reactive, which is so many other legal areas are.
Yeah, it's funny you put it that way because that's actually one of the comparisons I use with clients often in a first meeting is, when we're choosing planning strategies, even, are we choosing planning strategies that are proactive versus reactive? And that's going to lead us down certain paths. That's where we see such a heavy use of trust planning because it is proactive. We're putting the plan together and we're bringing everything into the plan. We're funding the trust, we're getting everything prepared. So, rather than talk to clients, just, here's the legal definition of every document that we might use. I like to talk a lot more about what's the intent, what's the feel, what are the goals, and then we kind of work in the legal strategies from there.
Absolutely, absolutely. So that's awesome. I really appreciate that. As you know, I call the show Estate Planning Nightmares and
Yeah,
how to avoid them.
yeah,
And people often ask me, why do you call it that? Well, because hearing stories, I believe, especially the not so pretty ones,
yeah,
help people to think about the what ifs, right? And
yeah,
hopefully be able to equate it to their own situation. And I think it helps people to understand the realities of what may happen without proper planning. So, Peter, you and I have known each other a long time, and I know you have seen a lot of the good, the bad, and the ugly. Would you be willing to share a story or two with our listeners today?
Yeah, I've got a couple in mind, and in some ways, I think each of these two examples can highlight both the bad, or when it can go bad, but also how we can avoid it, often in ways that aren't as complicated as we might think. I'll tell you, as an estate planning attorney, one of the most common terms we hear in a first meeting is "my family is simple," or "I'm simple," or "my assets are simple." And I just want a simple plan, which is fine. Simplicity is great, right? Who doesn't like things that are easy and simple? Now, there's two things going on there. Sometimes that's just code for the client saying, "I don't really want to pay you that much, so I'm simple," right? So that's part of it. But part of it is that, estate planning takes investment of not just money, but time to really do it right. And one of the most common simple strategies that we see that often ends in not so simple results is the over reliance on things like transfer on death designations, beneficiary designations, or even joint ownership with kids. We hear it all the time in a first meeting. Well, I've already got TODs on my bank accounts. I put a TOD on the house or the real estate. I've put my oldest daughter on as a joint owner on my bank account, and the clients like this because it was so simple. They didn't even need myself or another attorney to do it, right? They just talk to their financial advisor, their banker, etc., and they come in saying, "This is great. We're going to avoid probate," which is at a very simple level quite possibly true. One of the upsides to a transfer on death, joint ownership, beneficiary designation is it's a direct transfer. There's no probate. Everybody, kind of recoils at the term probate in general, even if they don't know what they're worried about. They still are afraid of it and don't want to go through it, which is fair. So they're coming in feeling like this is really simple. Well, there's a couple of huge downsides to these really simple strategies. Probably the biggest one is that if we do that in full, we do avoid probate, but we also avoid any one person, like a fiduciary, a executor, a trustee, a personal representative, having control over the assets to settle the affairs of the estate, right? So if we POD everything, it goes equally to our five kids. They all get it right away. But there's going to be bills to pay. There's going to be a funeral to pay for. There's going to be possibly some final medical bills, credit card bill or two here or there. And sometimes it's more, sometimes it's less, but there are going to be bills to pay. All that money is already in the hands of five kids, not in the hands of one fiduciary. Now I know what my clients are going to tell me. They're going to tell me that's okay. My kids get along great. They're great friends. They're all nice. They'd all do the right thing, and they'd all chip in exactly 1/5 of the funeral cost and all the other bills. And I love the optimism in that. And those of us who have siblings know that even if they're all great and we like them, that's not necessarily true that everyone's going to kick in their fair share. The example I always use with clients, because it's relatable, right, during lifetime is, if you've ever bought like a joint Christmas gift for your parents with your siblings, right? I'm going to go out and buy it. I'm going to spend $500. Everyone's going to give me $100 back. We all split it five ways. Now, I can tell you from experience, rarely do you get $100 from each of those siblings. You might get it from a couple. Maybe somebody gives you 50. Maybe somebody just forgets. Maybe somebody didn't have the $100 but wanted to be a part of the gift. And at the end of the day, it's not going to create any major hard feelings because you're going to eat the $100 or $200 and move on with your life. But if that $500 gift now post death is a $15,000 funeral for mom and dad, and is a credit card bill with a couple grand on it, and maybe even a hospital bill, all of a sudden the numbers ramp up, and it becomes pretty important to me that I get 1/5 back from each of my siblings, uh,
Well,
and
yeah,
that
we
costs.
both have children, right? And it and anyone who does. And as I always say, we can't agree on what to eat for dinner, what movie, to
Right,
all go see.
right.
And when money gets involved down the road, even as much as you think your kids love each other and don't fight, there's going to be a lot of disagreements that are going to go on. It's like, hey,
Yeah.
you pay, Peter. Man, mom and dad like you better than me anyway, so you just take care of it. I'm not paying out of my fair share.
Right. Or you're the one who picked out the casket and spent that much. You should have to, you should have to eat that cost. I would have just buried him in a bag, that kind of stuff.
Yeah,
So,
yeah,
so there's all these different perspectives. And what we have to remember is we're also dealing with people who are grieving, right? And people who are grieving behave differently than they do when they're not grieving. There's even, you can talk to folks who analyze the way the brain works in that way. So not giving excuses for sometimes bad behavior, but you're going to have differences of opinion. If I have three, four siblings, I don't just have three or four opinions. I probably have six or eight if they're all married in terms of how this should all play out and who's spending money and resources. But the baseline problem is that the money went directly to the individuals that were named, and they are going to be told by someone in their life, including maybe even an attorney who would be correct, that would say, you don't have to cut your share back. That's not a mandatory requirement because it's already your property. These direct transfers have a lot of problems when there's bills to pay, when there's sharing to go on. And the other problem is that they have no they're not influenced at all by what a person's will or trust does say. So a lot of clients fall under the false presumption that, well, if my will says it gets divided five ways, even if I named my oldest daughter on the bank account as a joint owner, I know that goes directly to her, but the will says it gets split five ways, so she has to do that. The reality is she doesn't. She has that money and it's hers. We had a client years ago now, probably more than a decade ago, where mom had listed each of her three children as the beneficiary on various CDs and other investments, but they were each the direct beneficiary of one of those CDs. Now, what happens when one of those CDs gets cashed out? One of them grows over a 10-year time period, one only over a two. They all have different values. And so directing these three beneficiaries, it ended up where one kid got nothing because their CD was spent down. The other two got different amounts, and there was no way to go back to the bank and say, hey, you got to fix this because the will says it should go three ways. The bank says, well, the will doesn't govern here. Those aren't probate assets. The will doesn't have any influence. So this over reliance on simplicity and the fact that the legal documents aren't going to govern is a real big trap. And even clients who've done their estate planning fall into this trap where, hey, you know what? I updated my beneficiary, but don't worry, the will's going to sort it all out. So we've seen some pretty bad results from that. For us, it's just
wow.
about counseling the clients, talking through almost those exact scenarios we just did, talking them through, the whole point of doing this is to avoid fights in the future. Let's not create fights where they don't have to be. One of the things I'll often ask clients when they tell me they're simple and they want a simple plan, I ask them if they want it to be simple now or if they want it to be simple later. Because those are two very different plans, right? A client who wants simple now just doesn't want to talk to me very long, doesn't want to pay very much, and will deal with the consequences down the road when they pass away. For a plan to be simple at the time of execution, at the time of administration when I pass away, we do have to invest some time and resources on the front end to make it simple for those that we love, which is ultimately, that's what estate planning is about, really, right? It's not about yourself.
Right.
It's about others. It's about the people you care about.
Yeah, exactly. It's you know, there far too many people have the attitude, even still. It's like, well, I'm gone. Somebody's going to figure it out. Well, you know, selfish much?
Yeah.
Uh, because as you know, the reality is that without the plan in place, family is going to court and they're going to need attorneys, and we can invest a little bit and do that proper planning on the front end, or choose not to and let it cost family a lot of time, a lot of money, and possibly a lot of divisiveness. So I always like to say, let's divide things, not families.
Oh, yeah. That's a great way to phrase it. And this idea that the kids will work it out or they'll all get along. It's just an excuse, really, to not take the time now. We often emphasize to clients that the cost of planning properly is far smaller than the cost of not planning. And not just, I mean, financially, yes, that's true. You're going to pay a lot more post-death if you haven't planned in advance, and your kids are going to lose that from the estate. But the cost is more than just the money, as you allude to. It's the relationships, it's the people, it's the siblings who the last time they talk to each other is when they get the check from the executor after mom died, and they never talk to each other again. And I can guarantee most parents, again, like you said, we both have kids. That's the last thing you would want as your legacy, is your kids not talking to each other, or not having a relationship after you're gone.
Absolutely. Absolutely.
Yeah. The other thing that we see, and again, it's a generic concept, but I'll apply some examples to it, is that sort of the failure to plan for the specific assets that we have and how that might play out in a shared ownership context, right? A lot of us are simple, again, right? We want to leave all of our assets equally to our four kids. Okay, that's great. That's a great idea. That's really easy with bank accounts and even with retirement assets, cash and liquid assets. You can easily divide four ways. It's just math. But what happens when the assets include real estate, include family businesses, include vacation properties that everybody has shared during lifetime? Clients often think, again, the kids will work it out. The kids will figure out how to share it or figure out who gets what. And far too often we see clients relying on I'm just going to tell the attorney what I want without thinking about or talking through how will it work or will it work to transfer assets to four people. An example that's really relevant here in Wisconsin is the family lake house, right? Everybody's got their family property. It's always up north somewhere, and it's always on a lake. There's apparently enough lakes for everybody, because the vast majority of clients have some kind of family property like this in our area. And the parents have this misconception oftentimes that when they're gone, some combination of all the kids will want to keep using it and they'll maintain it together equally, and they'll all pay their share of the costs and expenses and get along. One of the reasons they have this misconception is because it's pretty easy for the kids to share it when the parents are alive, because the parents pay for the real estate taxes and the insurance and the maintenance and the upkeep, and they're up there putting the pier in the spring, they're up there taking it out in the fall. And some of the kids might show up here and there to help with that stuff, but probably not all of them or not every time.
And
But
there's one of those kids that if mom and dad are gone, I'm never going there again. I don't like to fish. I don't like the bugs.
yep,
And yeah.
yeah. So you've got all these different perceptions on it, but the glue that holds it together, like with a lot in family relationships, is the parents, right? Because when in doubt, they'll pay the extra amount, they'll cover the cost for everybody, and they won't harp on anybody for not showing up and helping out, right? They'll just kind of let it slide and they'll smooth the relationships over. Well, now when mom and dad die, and they've got four kids, one of them lives down the road from mom and dad. One of them lives in Minnesota, and two of them are on the two coasts of the country. Those four people trying to share that property together is probably not going to happen even with good planning, but it's certainly not going to happen without planning. And so, the failure to plan results in fights. It results in hard feelings about who's contributing, both financially and in person. We've had families we've worked with where, a couple of people pay all the bills right on time, but they never show up to help with any of the work. And then the ones who show up with the work feel like they don't have to pay anything because they're doing the work. And even still, we're talking about people who all want to use it. Your example, well, the kid who doesn't want to use it, I'm never going to go there again. I only went there because mom and dad were there, right?
Yeah.
And so you have these differences of opinions and perspectives. You really need to take the time in the planning, not only to flush some of that out, right? Part of our job as attorneys is to challenge the clients on what they think will work, right? Is to say, You really think that all four of them are going to share it equally? Do they all use it equally now? Well, now that you mention it, Joe hasn't been there in years, and he actually never really seemed to like going when we took him up there as a kid. But you gotta make them say it, right? So that
Yeah.
they acknowledge
And then
where
do you
the
build into the plan like some provisions so that if so Joe doesn't want to be in there, so you know, then yeah, I want my 25% out. We're going to get the
uh
place appraised. You all
Yep.
are going to have to come up with the money and take me
Yep.
out.
Yeah, and you can get creative with it, right? Because the pushback is then, well, what if they can't afford to buy them out? Well, it doesn't have to be all at once. It can be over time. And you include the language that avoids the future fights. Because once somebody wants out, even in your example, right? Joe wants out, the other three want to stay in, and everybody agrees that that's a good result. Now, what's the challenge? Well, what's the value of the buyout? What's the value of the real estate? For the three staying in, it's the tax assessment value. It's the lowest value they can find, right? For the
Yeah.
one out, he wants an appraisal. He wants three appraisals and take the highest value and get the biggest buyout. You remove that through the drafting. You remove those challenges by saying we are going to get an appraisal, and here's how it's going to be determined. And Joe will want a family discount. Well, it's up to mom and dad to decide if he gets a family discount, not up to Joe and his siblings. So we draft all that into the plan so that if anybody's mad, they're mad at the people who aren't here anymore, right? They're not mad at each other for trying to pull one over on them or trying to kind of cut them out of their share. So on the real estate side, there's a lot you can do, but what you can't do is just say, I'm going to leave it to the three kids and they'll figure it out.
Right. Right. Yeah,
So
I mean, it's really, and again, as I always say, that's why I think it's so important. So many people try the DIY route and, you know, they think the online questionnaire is getting to things, but no one except a experienced estate planning attorney is going to have a conversation that we just had here. Look, mom and dad, what's going to happen with the house? You want the kids to fight? Here are all the potential arguments that are going to go through, but we can, circumvent that. And at the end of the day, not have kids hate each other.
yeah, and we have clients who say, look, okay, now they accept what we've said. They said, well, no, they don't all use it equally, but we think it could be an opportunity for them to all stay connected down the road. But we are worried. One of them, is a doctor, one of them is a school teacher, and one of them is in and out of work. So they have really very different financial positions. We might even say, okay, let's set that family vacation property aside. Maybe they really all do want to use it. Maybe we need to inject some funding into that too. Maybe we need to have a maintenance fund from our other assets that's created to give them at least 5 years to give it a try and figure it out without financial pressures, right? To give them a runway. We've got clients who have, really, really nice, valuable property, but they know none of their kids can afford the maintenance on it. And what they would do is they would just panic and sell, right? They would just sell because they need to get cash because they had no idea mom and dad were spending 150 grand to maintain it every year.
Right.
Uh, but if we take that time pressure off, again, maybe pushing the decision out from the immediate grief after losing parents and allowing them a chance to settle in and really figure out what this looks like for them. So there are creative ways to solve problems once we get the clients thinking about it. We see it with family businesses too. And I'm sure you've seen plenty of family businesses that are great at generation one and fail at generation two, or they break down at generation two and then fail at generation three. Again, part of that, yes, we have to acknowledge is there's a difference between being the one who started the business and the ones who inherited the business. But a lot of it is lack of planning, right? Not acknowledging if my son's going to take over the business and my other three children are not, how do I actually balance that within the estate? And this, touches on one of our favorite topics in estate planning is the distinction between fair and equal, and understanding they're not always the same thing,
Right.
right? And understanding that sometimes to be fair, you can't be equal. If that son has worked in the business as his entire career, and now that business is the largest asset of the person's estate. I don't know that we can necessarily just force the son to have to buy his siblings out. right? Part of the success of the business might even be credited to the son working as an employee during lifetime. And if we are going to have him buy them out, because we don't want to leave him nothing, we then have to think about, well, how can we do that in a way that won't ruin his career, ruin his business, and those types of things. It's family business is like the family vacation property times 100 in terms of complexity, right? Because dividing real estate ultimately can be done. Sharing the use of real estate is possible. Asking that child who's worked in the business to share the ownership and profit with his siblings of his livelihood, that's another story.
Yeah, that could destroy the business in and of
Correct.
itself. And I've often thought about that, when there is a business that, you know, dad had and ran, he's still in there, but one of the four kids get interested in the business and the others have no desire
Yeah.
to be involved. Yeah, fair does not mean equal,
Right. And
but
the kids who are on the outside not working in the business, they think everything's just been handed to the child who's in the business. Meanwhile, the child in the business maybe has barely been paid their fair wage the entire time because they're the child and the parents are expecting it of them. And there's these tensions. And these are the things that are in the back of the kids' minds during lifetime. And then when they play out in a post-death scenario without some really intentional thought and planning, all of the internal thoughts and feelings from their lifetime, they all just explode out at once. And that's where the big fights happen. One of when early in my career, one of the estate planning attorneys I worked for often said, the kids, when some mom and dad die, the kids are fighting about the same things they fought about in the sandbox, right? It's different words, it's different things, but ultimately it's the personalities, right? It's that are clashing. It's the hard feelings that they've harbored for all these years. And if they came out when mom and dad were alive, mom and dad helped to smooth it over. But I always tell clients when you pass away, you know what your kids lose? They lose the referee, right? The person who always broke up the fights and smoothed things over and made everybody happy again, or helped with the fairness discussion. When they're gone, it's the kid. It's every man for themselves.
oh, absolutely. Absolutely. Wow.
Yeah.
Really interesting. Yeah, I mean, this is just a really unique perspective because I like the conversation we're having today. It's not so much about, you know, I did one interview here not so long ago. Our listeners will probably remember where couple gets together, they got some small children, but the brother was still listed as beneficiary
Yeah.
on the life insurance. And, an honest mistake. If I were my brother's beneficiary, forgot to change it, God forbid something happened to him, I'd give the money to his wife. But
Yep.
this guy did not.
Yeah.
So if we think brothers and sisters all just love each other and will always do the right thing, we are sadly mistaken.
Yeah. And again, there's different reasons for it. Sometimes it's because the brother's just a bad guy and wants to keep the money and he's selfish. Sometimes the brother thinks, well, no, maybe they really did want me to have this. We had a relationship too. Uh, and sometimes it's even in between. Well, we had one where the similar situation, again, why TODs and beneficiaries can be so problematic. His money went to the brother, and it was adult children, not minor children, but adult children who should have inherited this insurance, never got around to changing it. That brother agreed should be used for the benefit of the kids, but he had conditions, and now he was playing sort of, the role of a trustee, but without guidance or direction and actual legal authority. So, no, I don't want you to use that money like that. No, I don't think you're mature enough to use that money. And it became this nasty relationship where the kids eventually said, "It's not worth it. We don't want the money. It's not worth having to deal with him." And his sort of seemingly relishing the control over them.
Yeah.
So yeah, it's interesting. I mean, it's all these things are avoidable. I think that's the thing to stress. When people hear these stories and hear these bad outcomes, it's not that difficult to avoid these things, but you do have to take the time and you do have to talk about it. The clients who meet with us and think they're going to have their plan done by next week, are in for a little bit of a surprise in that, no, we are going to take multiple meetings to talk through this. We are going to ask you questions that you might not have thought about yet, but this is why, right? Because we want the benefit of working with someone who does this every day is the experience they've had and their ability to apply it to your family.
Yeah, absolutely. It takes planning and it takes time. I mean, it's everything takes planning, right? I mean, human beings were planners by nature. We plan for, going to college. We plan for getting married. We plan a honeymoon. I mean, you know, this afternoon you might have to plan dinner. Think, all right, I'm going to stop at the grocery store, and what's the traffic going to be like on the belt line? You make a plan, right?
Yeah,
But
yeah,
so let's make a plan for the future that works. Take the time, make sure that our families and the ones we care about uh, have at least an easier time after you're gone.
yeah,
So,
yeah, for sure, for
say, is
sure.
there anything else you'd like to share with the audience? Is there like a question that maybe I didn't ask you? You're like, dang, I wish you'd asked me that question.
Well, one we get a lot, and I think it can be relevant for a broad audience, is, you know, especially in this day and age, why not just do it yourself, right? You watch a football game, they got trustandwill.com and they've got legalzoom.com has been around for decades now, and you can just hop on your computer, you never have to talk to anybody, and you just plug it all in. And there's two answers I always give clients. One is the individual doesn't always know the questions to ask themselves. That's the role of an attorney. That's the role of an advisor. And the software doesn't either, because the software might be asking the question, but they're not challenging your answer. They're not redirecting you from that answer. They're just taking your input and recording it. And the other one, probably the example I've used the most and historically is much simpler than that. It's, we can all choose the things that we do it ourselves for, right? Whether it's home repairs, whether it's, the plumbing in the house, whether it's my own taxes, right? We have to pick and choose where we're using professionals. Now, I can assure you I don't do my own plumbing at home, and for good reason. But I'll tell you the one benefit I would have if I did my own plumbing is I would know if I screwed it up because there'd be water everywhere, right? And then I could get it fixed and I'd have some damage, but I could still come out of it okay. The problem with do-it-yourself estate planning is you don't know you have a problem until you can't fix it anymore. You don't know you have a problem until you're gone. And now it's your kids who are left to deal with the mistakes that you made.
That is a brilliant analogy.
So, and again, don't worry, I'm not going to go home and do any plumbing. So, my neighbors don't have to worry. So.
Come on, I know your wife. She wants an indoor pool.
Right.
Oh gosh. Oh wow. Hey, finally, how can our listeners, if they want to reach out, especially if they're in Wisconsin, the area, how do they reach out if they have any questions and need any help with estate planning or business matters?
Yeah, one of the things I'm blessed with at this point in our career, and you know this too from our relationship, John, is we have a great team here. I think calling the office, uh, going to our website, and there's a way that you can submit a consultation request. You can call the office, you can email the office, and our team is super prompt in following up and identifying what the needs of the client are. So, I always encourage clients to just take that first step and reach out. We're not gonna bill you to talk to you. We're gonna sit down and have a conversation, and we're just gonna explore what we could do and how we might be able to help.
And full disclaimer to our audience, Peter is my estate planning attorney. Um, that's why he wasn't the first one on the show. He's on episode 53 or something.
Right, that's right. Got to get around. You
Um,
can't be too biased.
but his team is amazing. Everything they do is done with care and empathy and love for you and your family. So, um, well, Peter, I am super grateful for your time. It's always great to see you. Uh, I can't thank you enough for joining me today and sharing, with our audience a bit about you, the firm, and some of the challenges that lay in wait. Right?
Yeah, well, likewise, John, I appreciate your time, appreciate the invitation. Look forward to connecting again soon. I'll have to make my way down to your warmer climates again here soon.
There you go. And a big thanks to all of you, our listeners. I really appreciate you joining us for another episode. Feel free to reach out to Peter and his team if you have any questions at all. To make it easy for you, I've included all of Peter's contact information in the show notes. As always, if you found this episode helpful, don't forget to subscribe, give us a thumbs up, leave a review, and by all means, share it with someone who needs to hear it. Until next time, remember, your life is your legacy. So plan ahead and make it a great day.